Good morning, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. We really appreciate you taking time to be here today. And we are going to be discussing a topic I think is on the minds of a lot of folks regarding the new virtual reality we all deal with in the courtroom. So today's program is sponsored by our Commercial Litigation Practice Group. And we are fortunate to have with us today three presenters who know their stuff. They are in the courtroom all the time and working on litigation all the time, so we're happy to have them. And I'll introduce them briefly here, and then I'll get you more biographical information about them shortly. We have with us today Matt Betcher from our Commercial Litigation Practice Group, along with his colleague, Brooke Nosenchuk, and from our litigation support team, Andrea Bergen. And so, like I said, I'll mention a little bit more about them in just a moment. But before we get started, I want to mention that we are dealing with a lot of litigation remotely these days. And this program is designed to give you some best practices, some tips, maybe some strategies, some deep thoughts about this topic. And so let me tell you a little bit about our firm. We're going to dive right in and get going. So for those who don't know much about Plunkett Cooney, we are one of Michigan's largest full-service law firms, and we actually have offices in states like Illinois and Chicago, Illinois. We have locations in Indianapolis, Indiana, and in Columbus, Ohio. We have 7 locations in Michigan. So our commercial litigation group, if you're not familiar, includes attorneys and legal support staff who focus almost exclusively on business litigation. And so that's practice takes them throughout our state courts system and our federal courts as well. And they deal with a range of issues ranging from complex antitrust cases, corporate compliance cases, tax and finance disputes, business ownership conflicts, the list goes on and on. Our speakers today, as I mentioned, are Matt Betcher, Andrea Bergen, and Brooke Nosenchuk. And so let me tell you just a little bit about each of them, and I will turn over the program so they can dive into the content. For over 30 years now, Matt Betcher has successfully represented clients in complex commercial litigation on an array of issues. This includes real property disputes, banking conflicts, contract disputes, class actions, and business torts. He's a co-leader of our Commercial Litigation Practice Group, and he has received numerous honors and awards over the years, including a peer review rated honor from Martindale-Hubbell, which is a leading international peer review rating service. And he's also received the top lawyer designation from outlets like media outlets like D-Business Magazine, for example. Those of you in the Detroit area should be familiar with D-Business Magazine in the area of commercial litigation. Now, Brooke Nosenchuk is an associate here in Plunkett Cooney's Bloomfield Hills office. She works with our partners to resolve often complex commercial lit in state and federal courts, as I mentioned. She's a graduate of the U of D University of Detroit School of Law, and she leverages technology to help create what we describe as persuasive trial exhibits and presentations that position cases we hope for success. And so we're happy to have Brooke here as well. And last but not least, Andrea Bergen, who is a longtime member of our firm, and she is one of the backbone litigation support pros here at Plunkett Cooney, in trial all the time, and she has extensive experience assisting our attorneys in the preparation of presentation of cases in traditional court proceedings, as well as now virtually, and even in hybrid situations. So she's an expert on trial presentation software, and she's one of our go-to professionals to really make sense of all the technical jargon none of us wants to deal with. So we are certainly glad to have Andrea here. Just a couple quick housekeeping notes, and I promise I will stop talking. For our Q&A portion of the webinar, we're going to use our chat function. So if you're not familiar with it yet, take a look at your navigation display. You should be able to find the chat, and you can type in your questions as you think of them. And towards the end, we'll try to answer as many as we can. Finally, I want to mention that today's session is being recorded, and it'll be available on Plunkett Cootie's website on the event page for this program. So if you need to take a peek at it again to catch something maybe you missed, or you want to share that with a colleague, we recommend you check it out there. So with that, I'm going to turn it over to Matt Betcher, who's going to start the program. So Matt, please take it away.
Thanks, John. Good morning, everybody. Appreciate you being here, and I want to thank Brooke and Andrea for joining me today as well. The impetus for this webinar was really kind of a bad experience. I was having a remote hearing, and everything that seemed that could go wrong was going wrong. And it occurred to me that this isn't unusual, but it certainly created new challenges that as an old-time lawyer who still remembers using carbon paper, if you believe that, this age of remote litigation is quite a shock for someone like me. So my thought was, well, let's do a webinar where I talk about all the things that blew up in my face, and we can take those lessons and use them to more effectively present litigation remotely, or, as I think is going to become more often the case, as well, if you heard the president, the pandemic's over. The courts haven't necessarily caught up with that, but more and more, I think the courts are hoping to get proceedings live. But I think what the pandemic has taught us in part is that the days of litigating by video are here to stay. Either in pretrial proceedings, or even when we're trying cases in courtrooms, I think you're going to be seeing video presentations more and more frequently. In my day, it was extraordinarily unusual for anyone to not testify in person. And in fact, when that person wasn't available, for most of my career, there just wasn't technology available to have video presentation. You would take a deposition and read it into the record. And if you want to put a jury to sleep faster than that, I don't know how. So as we get going with this presentation, and we talk about challenges of remote litigation, I want to just talk about a few things that became very apparent to me very early on in the pandemic back in 2020, when I first had to start using Zoom to do hearings. All the trials got adjourned in Michigan, but hearings, for the most part, once people figured out how to use Zoom, started to proceed regularly. In fact, I wound up trying a bench trial in federal court over 3 days by Zoom, which maybe I'll talk about in a minute, because that too created some issues that I wasn't prepared for. But first and foremost, for those of us with gray hair and do remember carbon paper, litigating over a computer, or even talking over a computer like we're doing now, requires a skill set that many of us don't possess. I'm looking at my laptop right now, and I don't see myself on the screen, but I'm looking right at the camera, and I'm sitting up straight, and I'm trying to talk directly. But that's not how we typically talk on the computer. I was watching a motion call in one of the local courts here a few weeks ago, and I'm not kidding you. The attorney's computer was like that, and all you could see was his belt buckle, and he didn't realize it until someone had to say, we can't see you. Can you move your camera? And this was after the attorney had started talking. Another issue that happens to me quite frequently. I don't yet have a stationary camera on my video monitor. So if I'm actually looking at my monitor now, I'm not looking at my camera. And that can be very distracting to a witness or to a judge when you're kind of talking off into the corner and not to them. That's just one of those things that you have to get used to. You have to train yourself to do that. And again, I'm speaking personally, but I think my experiences are particularly unique for those of us who did not grow up with computers. Computers are still somewhat of a mystery to me. Another issue that comes up frequently, and again, these are more professorial things, attorneys often don't think about their background. You know, I'm in my office right now, and I've put a little filter on the camera so you can't see how messy my office is. But I was in a hearing, and I was watching a lawyer who didn't realize that, you know, he was sitting at his kitchen table and we could see his kitchen counters behind him, and he hadn't done the dishes, and it was a mess. Or there was another example, I'm not making this up. The lawyer was in his basement, but his camera was kind of pointing up at the ceiling, and we were all kind of watching this spider walk across a beam on the camera. And if you don't think that's distracting, it is. You know, if you can see this spider walk, is he going to fall on the guy? You know, is he going to jump? What is he going to do? So those are the types of things you don't think about until you have to think about it. I know one of the things that another law firm, I was in a deposition yesterday, they to try to eliminate these issues of what does the background look like, they moved down to a conference room, which say, okay, that makes sense. That looks more professional, but they hadn't tested out the acoustics. So everything that was said in this conference room echoed, and they only had one speaker, which created feedback. And the volume setting on the computer wasn't adequate. Nobody could hear them unless they were leaning right into their computer like that. These are the types of things that they seem silly and they seem minor, but if I'm a lawyer and I'm presenting your case to a judge who's going to decide your fate, I want the judge to be looking at me and to be paying attention to me and not wondering what that mess is behind me, or is that spider going to fall on my head? Some of the things to think about. And when we were preparing for this, I was talking with my colleague Brooke yesterday. Brooke has a kind of a unique sense of this. Brooke is a lot younger than me, so I thought she would be a perfect foil to me and explain some of the issues that younger attorneys don't think are an issue, and things that younger attorneys aren't viewing as problematic because they grew up with this. Brooke, jump in here.
Yeah, so in my experience, it's quite different from the Matt Betcher experience here. Most of my law school was online. So I started law school in 2019 in the fall. So I had one full semester in person with in-person classes, and then about 2 weeks more into the second semester. And then I was completely online for the remaining, two years in one semester. So obviously, it was a challenge at first, but being that I grew up in an environment where computers were so prominent, I quickly adapted to the remote classroom. I remember even in elementary school, being in first grade, second grade, I was taking computer classes, which is unique for my generation, being a new associate. So going back to my law school experience, now that wasn't easy to transition to the remote format for many of the professors who have been teaching for 20 plus years in a in-person classroom. So they were accustomed to cold calling their students, having a, Miss Nosenchuk, please stand up and explain to me, and then some case. When in a remote environment, students could easily type in the Zoom chat, sorry, my mic isn't working, as a cop-out answer if they didn't know the answer to the professor's question, or they actually, maybe the mic wasn't actually working. You never actually know. So if the student keeps being unable to speak in the virtual classroom, that only makes that student look more unprepared. And that certainly won't fly in a courtroom, sitting in front of a judge. So it wasn't, also, it wasn't out of the ordinary for a professor to cancel class just because of technical difficulties, or just to give the professor more time to learn and navigate how to use Zoom and some of these new platforms. So I think that my experience of online law school was very unique, but only better prepared me and other recent law school graduates for the remote litigation environment.
So I think that sets up a good point, and it's what I want to leave you with as we transition into a discussion about technology, is that we've now lived through a couple years of remote litigation. I think most lawyers are fairly comfortable clicking on the Zoom link and sitting in the waiting room waiting for their case to be called. But I don't think as we go forward with this, that's going to be enough any longer. The expectations of the courts are getting more sophisticated. Whereas back in 2020, they may have been fairly forgiving about lapses with computer or bandwidth. Now I think we're going to get more and more where that's simply not going to be tolerated. And frankly, it doesn't look very professional when out of the blue your computer dies, or your battery dies, or your audio link starts breaking up. That's going to happen, but the expectation will be of courts and of my clients is that you've had 2 years to work this through. I don't want to see that any longer when you're presenting my case. And I think law firms need to understand that. So as I started my comments, lawyers, even aged lawyers like myself, we have to develop a new skill set. And some of those skills are, frankly, they're not going to come from me. They're going to come from people like Andrea, who we're going to talk about right now. Because as we talk about remote litigation, and let's just say a hearing that I'm going to attend from my office through Zoom, and we'll talk a little bit about kind of hybrid remote litigation in courtrooms, but it's important now that law firms examine, assess, and create this quality and depth of their technological capabilities. So I want to invite Andrea to talk a little bit about, first off, what her experiences are presenting, remote capabilities in a courtroom, which is kind of that hybrid issue that I made mention of just a moment ago, as well as some of the issues that confront us trying to litigate claims, from an office. And I'll chime in a little bit on that. Andrea?
Sure. So our litigation support department, we really work to try to keep some of those distractions at bay that Matt was talking about. While I don't have control over spiders in people's basements, what we do have control over is helping our attorneys keep distractions at bay for their case presentation. Because we do the job we do, we allow them to do the job that they are there to do. So the attorney is able to focus on case presentation as opposed to, troubleshooting any technology, things that any snafus they come across, they don't have to worry about that. That's on our shoulders. And we have a depth of knowledge and experience. We accompany the attorneys to trial live in person and display our, exhibits electronically. We've done hybrids where, I had a trial that was live here in Wayne County, and a couple of the witnesses were they had gotten over COVID, but they were still testing positive, so we didn't want them in the courtroom. So they were able to come in and testify via Zoom while the jury and the attorneys and, you know, the rest of the witnesses were actually live in the courtroom. We have
Andrea,
also done.
let me stop you there just for a second, because I
Sure.
think that's going to become more and more normal. Again, in my old days, if your witnesses were from California, so what? Get on a plane and fly in. If your witnesses were ill, so what? Get on a plane and fly in. I think courts, even though there are provisions in state and federal rules that permit for exceptions, you know, the judge is the final decider of how the trial is going to run. Judges have pre-pandemic been very reluctant to deal with a remote witness. My experience was one time pre-pandemic where a judge allowed a witness to testify remotely. I won't tell you who the judge was, but he was old like me and kind of a curmudgeon, and just didn't think that fit in our sense of jurisprudence. But once we did it and it went off seamlessly, he was sold and he thought this was great. But it introduced a whole host of new issues. And these are things I want to make sure Andrea talks about, which is understanding your hardware, your software. What is the court capable of? How is the court set up? I watched a situation, and then I'll shut up and let Andrea talk, where a lawyer came in very sophisticated, was going to do this entire video presentation. And it was a big case. It wasn't a trial, it was a summary judgment motion, but there was going to be an evidentiary hearing that was kind of part of it. We'll call it that anyway. And the lawyer was, you know, running around like crazy, and the judge was ready to take the bench. And the lawyer realized that the electrical outlets on the counsel table weren't connected to anything. And so the lawyer couldn't connect his computer and his video setup to anything, and didn't bring an extension cord. I mean, it was a disaster, not for me. It was kind of good for me, but you don't want those types of things happening. So Andrea, talk a little bit about that, you know, the hardware software aspects of litigating remotely and in a hybrid remote situation in court.
Yeah, absolutely. So even if we're doing a live trial, we typically like to go in and get a feel for the lay of the land. We go in and we take a look at the courtroom we're going to be working in. You know, we contact the court staff and we set up an opportunity. If we're going to be live in the courtroom, we set up an opportunity to go in and test our equipment. You know, we have, you know, meaningful discussions about what kind of technology the court has, and we're aware of what technology we have. That's why testing is so important. If it's going to be a hybrid or a Zoom hearing, you know, oftentimes we'll ask them, you know, could we set up a test just to make sure that everything is, you know, going smoothly? If they have some time, usually they'll set that up, you know, like a separate day, you know, or they may just say, hop in the call 15 minutes early and, you know, we can, you know, test things out. You know, those are a little more daunting because you have to be able to think on your toes a little more if you're having issues to be able to troubleshoot anything. You know, that being said, we keep, you know, a host of equipment to make sure that, you know, especially live, that we're not going to run into problems. You know, we have a trial bin that we take with us. Even if the court has technology in the courtroom where all we need to do is take our laptop in and plug in and they have everything we need to display it, we are never satisfied that there may be, you know, that we could avoid issues with that. So we typically in our vehicles, we keep a screen and a projector and everything we would need that, you know, say the court system went down, we're still able to present our case. You know, we have extension cords and power strips and, you know, extra laptops in case one of our laptops crashes. We have a full backup on a secondary laptop. So the biggest takeaway is having those discussions with the court to find out, what kind of technology do you have, and can we set up a time to go ahead and test what we have to make sure that this is going to go off without a hitch.
And those are all great points that if we had more time, I could share actual war stories about that. But if you look at this photograph on the screen of the judge staring at the video screen with the camera above, that's not a bad setup, but you're not going to see that in every courtroom. Every courtroom is going to be different. And the courts are going to put the burden on the lawyers to understand not only their own technological capabilities, but to understand that of the court. And it's going to be different everywhere you go. And when you're doing these hybrid type proceedings where some of it is video and some of it is live in a courtroom, you've got to understand both. And John, if you hit the next slide, this is actually where I have found more problems arising than dealing with the courts, because the courts will typically say, well, this is what we have. You just have to make do with what we've got. You just have to understand it. But it's the client. So when I was doing my my bench trial by Zoom, and I wanted my client to testify, we suddenly realized that my client didn't have sufficient bandwidth at home to have a stable connection. They kept breaking up and falling out. So it isn't going to be enough to understand your own technological capabilities or those of the courts. Now there's a new layer here. Now we've got to deal with, all right, what does my client have? Is my client going to be able to fully participate in these remote proceedings, particularly if they're distances away? That can create issues. I had a deposition that was going to be scheduled just last week remotely, and I had to remind the other attorney, oh, by the way, you understand my client is 3 hours behind us. They were in California. And it had never occurred to the lawyer. When they sent out their deposition notice for 9 o'clock in the morning, I said, my client, that's 6 in the morning for my client. So those types of issues, when it seems so easy, oh, we'll just schedule a Zoom call. All right, well, what about the time differences? But getting into the issue of client technology and capabilities, I touched on a little bit of hardware and software, but Andrea, if you could talk a little bit about this and steps that you've taken or things that you would typically do to understand, these same issues as it relates now to the client who's going to have to participate remotely.
Yeah, again, testing is key. You want to do it as far in advance as possible to make sure that things are running smoothly. And if they're not, then you can start troubleshooting. There are websites that you can access that will allow you to remote into someone's computer. So if they're, extremely not tech savvy, then you can actually get in and take a look. You could set up a Zoom call and have them share their screen to take a look at, let's look at these settings. This is where I need you to click, and kind of walk them through it. But ultimately it just really comes down to testing. And unless somebody's working on a Mac, I think that the general population tends to work on PCs, so that in our situation, it's usually easier to troubleshoot, because I'm able to even send them an email with screenshots of, what I'm looking at on my computer, and say, this is where you want to click. This is the setting that you want to get. This is what mine looks like. You want to make sure yours is set up this way. The last ditch resort, if they're having that many issues, is setting up a face-to-face meeting and just saying, can you, come to the office and bring your laptop and let's take a look at it and see what you've got going on.
One of the things that comes up very often now, even as COVID restrictions have been lessened, if not eliminated in many areas, the remote deposition has become more of the norm than the exception. And one of the difficulties that I have found in effectively questioning a witness is the presentation of exhibits. In the old day, I would come in with my stack of exhibits, and there'd be 5 copies paper clipped together, and I'd hand the exhibit to the witness and, question that way, which works, when you're Zooming because you can screen share, but it's more cumbersome when you now want to take that exhibit and maybe highlight a portion of it or compare and contrast it with an earlier draft. Say, for example, you're using a contract and you want to say, all right, well, let's look at the draft of this contract before it was signed. And you want to compare that. But now you're trying to flip back and forth between exhibits on Zoom. And it's very cumbersome to do. It takes extraordinary amount of time because you're invariably going back and forth, back and forth, back and forth as the witness saying, all right, I don't remember what the other one said. Let me look at that again. One of the things that we can do when we know that's going to be an issue, well, I'll let Andrea talk about that, as it relates to the presentation of evidence. Are you limited to 1 page at a time? How are we set up to effectively present evidence, either through a remote proceeding like a Zoom deposition or in a courtroom when many courts are now requiring exhibits to be presented electronically?
Right. So litigation support, we use specialized software when we are in the courtroom live to display our exhibits. And over the course of doing some Zoom hearings and trials, we have found that we still have the capability to use that same software. John, if you could stop sharing your screen for a second, I'll go ahead and share mine here, just so we can get a look at what it looks like. So let's see here. Okay, so typically what you would see in the courtroom is, like Matt was discussing, say we wanted to compare this page to, a second page of a contract, you're having to go back and forth, back and forth. The nice thing about having that technological background and having the specialized software is, we can actually set it up so that you're presenting to see both pages side by side. So if this were a contract and, it were duplicate, you can actually, follow along and say, okay, well, point 1 here, well, yeah, this is where the difference lies. And that's what the issue is. The other nice thing is with the trial presentation software that we use, screens can be a little difficult to read. If we only want to talk about, say, this point here, we have the capability to call that out so that, people aren't, well, hold on, let me get my reader so I can see what's going on here. It's pretty sophisticated and, a very effective tool to make your presentation not only in the courtroom any longer, but, via Zoom, since this software is so easy to use and translate through there. John, you can actually bring the slideshow back up.
Yeah, so this may seem rudimentary to some, but I can guarantee you, people of my generation, it's a mystery. And I'm going to share a story that I shared with my colleague Brooke. I was at a concert. I got tickets to see Eric Clapton recently, and sitting next to me was a young lady who was, I thought she was simply taping one of the songs on her phone. No, she wasn't doing that at all. She was live streaming the concert to a friend of hers, commenting on it, reading comments back, reviewing and sharing on other social media like Facebook and Twitter and never once did she do that using 2 hands. It was all with 1 hand. And I was watching part of this going, 2 thoughts. 1, these tickets were very expensive. Why are you doing this? And not just watching the concert. But the other was, how on earth can you do that? I had the same type of phone, and it made me realize I'm probably utilizing maybe 20% of the capabilities of my phone, which again led me to question, if that's true, how much of the technology that's available to me to present matters in court or in remote proceedings am I actually using effectively? And one of the things that lawyers are famous for doing is waiting for the last minute. So I have really tried hard to make sure when I know I'm going to have an issue come up, that I get with our litigation support people early and we talk these things through. And how are we going to be able to best present, our evidence? Again, I grew up in the day where you showed up for trials with your stack of paper and maybe you had some blow-ups on foam core boards or big cardboard cutouts. And you had your easel. My easel's in the corner of my office over here. Thankfully, I haven't used it in years. But maybe Brooke can talk to this. And again, I want to get back to this issue of expectation. There's a level of expectation, particularly with younger judges and my younger clients, that they grew up with these types of capabilities and are a bit baffled. It's become somewhat of a joke, when you got to help someone to work their phone, but that does happen. I don't think it happens as much with people who grew up with these types of technologies, but as we proceed post-pandemic in these areas of remote proceedings and hybrid proceedings in courtrooms, it's not going to be acceptable any longer that you're just kind of figuring it out as you go. And frankly, and I'm not going to have a chance to really touch on this too deeply, but there are ethical issues for lawyers. We are governed by ethical standards. And just like you can't present a trial when you haven't properly prepared, that's unethical. I can only imagine the opinions are going to be coming down someday where the failure to understand and properly use technology is going to be viewed from an ethical lens. So we want to make sure we are on top of that. If for nothing else, then to show that our clients that we're thinking about these issues as we move forward. So as someone who is kind of elder at Plunkett Cooney and is likely going to be in charge of the cases that I'm working on, John, if you go to the next slide, I want to touch on a couple things. This is obviously not an unusual idea when you have a significant matter and you're selecting your team. It's going to be me. Do I need an associate? Do I need more than one associate? Do I need legal assistance? Those are the questions that we asked in every case. But now there's an entirely new layer of assistance that you got to ask yourself and be prepared to ask yourself hard questions and explain these things to your client as these issues come up. What type of technical support am I likely to need? Is this going to be a remote proceeding? Is this going to be largely remote? When we go into court, is it going to be a hybrid presentation? Are we going to have remote witnesses? We're certainly going to have technological issues in the presentation of our evidence because, as I said, in my experience, many courts, they don't want paper any longer. Maybe in a bench trial, you'll get away with it because you're not dealing with a jury, but when you're dealing with a jury, that's just the most effective way to present your evidence. So you've got to ask those questions. What type of visual and audio support am I likely to need, or document handling? And can I do it by myself? Or am I going to need an associate who's versed in all of these things, or someone like Andrea, who comes into court? Andrea has been in trials with me on more than one occasion. And just knowing that I don't have to manipulate the documents, presenting them to the jury, so one less thing I had to think about. But I will say this, Andrea was there for the first day of the trial, and I think she had a conflict the second day, so I had to do it. So knowing that you have litigation support to help you on these things, that's not going to be a substitute when things happen. You know, Andrea had a conflict and she couldn't be there, or it might be simply got stuck in traffic, car broke down. Attorneys need to have these skills as well. And as clients engaging attorneys, you need to ask those questions. You know, how well versed are you in these areas? What type of capabilities can you bring to bear in the presentation of my case? Those are all questions that need to be asked.
Matt, just to add something here, I'm sure in my experience, I'm sure most of you have had this happen. Maybe you're on a Zoom call and your laptop or computer crashes or Zoom shuts down for some reason. These are the things you just don't think about until they happen. And so these technical difficulties have the capability to make or break what you're trying to say in a courtroom. It can make the attorney look unprepared or even incompetent just because you don't know how to use or navigate Zoom. So having a team of people like Andrea here, there to support your technological needs in a courtroom, whether virtual or not, only makes your case look stronger. It makes your team of attorneys seem even more prepared for anything.
And those are good points. And this, you know, the technology needs, we've touched on these issues already to some degree, but I want to talk a little bit about security, because having compatible computers and cameras and speakers, very important. You know, again, it gets to this issue of what's going to happen in the courtroom. What capabilities do your clients have? But the internet connection, I can say with almost absolute certainty that over the past 2 years of the pandemic, there have been technical issues with internet connectivity in every single Zoom proceeding I've been a party to. Every single one. It happens to some degree. And in fact, that 3-day bench trial that I tried in federal court back in 2020, it was my issue. There was an issue with our internet. I to this day, I don't know what it was, but I kept getting dropped from my own trial. And thankfully, it was early on in the pandemic and the judge was very understanding. But at one point, I was kicked out of my own trial for almost 45 minutes. Well, you know, things are going to happen. We don't have complete control over our technology, but if there were steps that we could have taken to try to shore up that internet connection and didn't, well, that's unacceptable. It was, as I said, it was very early on, and people were just figuring out, you know, how much load is the Zoom going to be when you've got, in our case, you know, 140 lawyers, and if half of them are trying to use Zoom at the same time, that's going to burden your system. The other issue, and I see we're actually running out of time, but I'll just touch on internet security. When you're dealing with a remote proceeding in court, security probably isn't the issue here because they're public proceedings, right? Anybody can participate, anybody can watch them if they want to. But when we talk about remote proceedings, we have to think more broadly than that. It isn't just what happens in front of the judge or in a deposition. It can happen in your planning, you know, your client meetings, right? Sitting down and talking, preparing witnesses to testify, assessing evidence, discussing strengths and weaknesses of your case. And you're going to do that remotely. You know, are you secure? Can someone hack your system if they tried to? And listen to what you're doing or record what you're doing. Those things have happened. We've seen newspaper reports about that. People being hacked. They don't even know they're being hacked. So one of the things that you want to do, you want to at least ask the question, if we're going to do these things remotely, is security an issue? And what can you do to make sure that we are secure. You know, in the old day, we just sat down in a conference room, shut the door, and we didn't have to worry about that. Or we used a landline. We have a landline in our office here, but I can tell you over 90% of the phone calls that I'm taking are people using cell phones. They're not, those simply aren't secure. So that's an issue maybe for another webinar where we talk about security and litigation. If you flip to, I think we've already talked about this to some degree, you know, Andrea's comments about document handling through electronic platforms and the attorney's ethical obligation. But I just want to stress that this is an emerging skill. Again, I think the lady at my concert who was able to do, you know, multiple things with one hand simultaneously, maybe she doesn't have these challenges that someone of my generation does. And I just have to understand where my limitations are and what I need to learn in order to effectively present my clients' cases. But it absolutely is a new skill, and it's not always intuitive. I'll concede right now, the first time I had to link onto a Zoom hearing, the very first time, I didn't know how to do it. I needed written instructions from somebody. And you may chuckle at that, but that's the truth. I didn't know how to do it. When they asked for a meeting ID, what is that? You know, a password? Where, you know, my password? What password? And believe it or not, I have some clients when we are trying to do things remotely, they're having some of those same issues. It's the first time they've ever been involved in a lawsuit. They don't have the depth of experience in litigation that I do. And I always have to remind myself, these things, even someone like me, where this has become second nature to in some aspects, for some of my clients, even sophisticated clients, it's brand new. And you have to walk through that. What I have found, the answer to this is what Andrea has been talking about, and what I think Brooke has implicated in her comments is that practice, practice. Just because you did it once doesn't mean it's going to work a second time. Practicing what you need to do. You know, we sometimes do mock trials leading into a trial just to see how a jury is going to react to an argument. Well, maybe you want to do a mock trial to see how the jury is going to react to the presentation of your remote witness and or your video evidence, because that could be telling. It may be worth it to you to fly in the witness to testify live when remotely you just aren't getting the same punch, the same bang for your buck. Hit the next slide, if you will. This is also an issue that sometimes is very often overlooked. I'm going to do a bench trial actually tomorrow. It's a small trial. It shouldn't go longer than a day. And we're doing it live in person. And the judge has said, you know, paper exhibits are fine, not an issue. But when you are coordinating for a video proceeding, whether it be a deposition, evidentiary hearing, a trial, we talked about understanding the hardware software capabilities. Well, now let's just deal with logistics. How do I make sure everybody who needs to have those exhibits has them when they're going to be used? Again, in the old days in trials, we'd show up, the exhibits would be listed on a final pretrial order. Everyone would have copies of them. Everyone knew at least the scope of the evidence that could be presented. But in a virtual proceeding like this, you may not have that, or you may have to make sure everybody has the evidence that you're going to present, not only in a link to a computer, file share program, but also you may have to send them paper copies ahead of time, just in case, again, the world collapses. and you can't get the video presentation to work, it's this kind of fallback. You know, I think Andrea mentioned when we do trials, we always make sure we have a box of all the exhibits just in case everything goes to heck and the technology fails. So that's something that doesn't change, but you got to make sure that when you send, I've received lots of file shares that are simply not compatible. I couldn't open them. And, you know, Brooke mentioned in her law school experience, students saying, "Oh, I can't hear you. I can't participate." Well, I've actually had not witnesses, but lawyers who I'm not sure I trusted them all that much, and claiming they couldn't enter, you know, they couldn't get into my documents. And I wasn't confident that was the case. I couldn't prove otherwise, but so this is the simplest document share file that I've ever used. You just click on it, but they kept saying they couldn't open it. So you want to think of those things before they happen to you. Okay, last big thing before we see if there's any questions, budgeting. This is oftentimes what my clients are very interested in from the very beginning. You know, can you give me a budget? You know, can you tell me how much this litigation is going to cost? One of the things that I think was one of the ancillary benefits of the COVID shutdown and everything being done remotely is that there were some savings. You know, lawyers weren't having to drive to court or to depositions or to meetings. You know, those types of tasks were being completed more efficiently, and hopefully that translated into smaller charges from the lawyers to their clients. But on top of that, now you have a potential new layer of cost that has to be talked about at the beginning of the case. And if it's not, it should be. And if it's not being budgeted for, it should be. Because if you're going to have technological demands relating to a remote case, you need to know what those costs are going to be before they come up. You know, I think we're all, or those of us who with litigation experience know that we've had the case where there's 1 million documents and we have to get the document handling contractor in with the analytics to help us figure out what's there. But now we're talking about something as simple as, all right, do they have the right computer? If not, do they have to buy a computer? Do they have the right audio for this? Or is it simply budgeting for the cost of someone like Andrea coming into the case like an associate would be, or a legal assistant would be, who heretofore you haven't thought of as a line item when presenting litigation costs to the CFO or to whomever's monitoring those things. So we're quickly running out of time. I want to make sure we have an opportunity to take some questions if there are any. But I could probably talk a whole hour on budgeting for litigation and what the new demands of remote litigation and how that is going to implicate in your budget. But I think those of you who are familiar with these areas, that's probably something you're already thinking about. What savings are there for me because we're dealing with remote proceedings? But now think about what new costs are there that you may have to anticipate and understand that those are things you're going to incur. John, do we have any questions?
I just wanted to. Yep, I wanted just to remind everybody real quick, Brooke. The chat function is what we're using for questions today. So if you could just quickly type your question in there, we'll get to them. Brooke, take it away.
Thanks, John. So I see somebody had asked a question in the chat. We have all learned during the pandemic how to navigate Zoom. How is what you're talking about different than that?
Well, Zoom is really just a platform. It's a video platform that gives you some convenience of being able to participate with multiple parties. And in some cases, I think my Zoom record is close to 300 participants in a Zoom proceeding. But the reality is only a couple of them were talking, and that still made it workable. When you're dealing with remote litigation by Zoom, as we've been talking about, you have to think more broadly than what's simply going to be the program that I click on in order to access the proceeding. That gets you in the room, but it doesn't deal with the hardware, software practicalities of that presentation and the things that we've been talking about, the camera angle, the speakers. I was drinking from my coffee cup. I actually was in a hearing and a judge started yelling at another lawyer who took a drink from a coffee cup, saying, "Would you be drinking coffee in my courtroom?" Well, I'm not in your courtroom, I'm in my kitchen. That was what the lawyer wanted to say. Yeah, Zoom is a platform, but it isn't the answer to the questions that we've been talking about today. Anything else?
I think we might have time for another question. I think this is a follow-up. We have our own IT group that assists us with our computers. Can't we simply use our own people to work with the attorneys to save money?
Yes, you can. But in my experience, it's more important that your IT people are coordinating with our litigation support. As the lawyer who's going to try the case, I've got so many balls in the air. There's only so many things I can deal with at the same time. And frankly, I don't understand some of the language that your IT people are going to use. I remember the first time one of the IT people talked about sending me a zip file, and I pretended I knew what that was. And this was years ago, but I didn't. Went to Andrea, "What's a zip file?" And she told me what it was and how I opened it and what I needed to do. But yes, we actually will rely upon your own IT people to help coordinate these issues that we've been talking about.
I have another question here in the chat. Do you find that in a way you as an attorney are thinking more like a TV or movie producer than just a trial lawyer when preparing your case for multimedia?
Yeah, I mean, in a sense, the issue of the camera angle and am I staring at this screen or that screen? I didn't realize how difficult it was to sit up straight for 6 hours during a proceeding and not slouch. And during this presentation we've been doing, my wife has called me twice on my phone and I've had to dodge her call. Those things can happen in a courtroom, but if I'm going to court, my wife will know I'm going to court. When I'm in the office, she thinks she can reach me. So there's a lot of distractions that just are attendant to this. And I'm surprised my assistant hasn't come in the office to drop off my mail. There is a production quality to this, and sometimes that's going to mean I can't do this in my office because I'm too accessible. And it's not going to surprise me that Plunkett Cooney develops its own little studio where we're going to, have everything we need in one room to do these things. We haven't gotten there yet, but we're getting there closely because we have conference rooms that have audio and visual capabilities that simply don't exist in my own office. So there absolutely is a production quality if this is going to become more the norm for presentations of cases in court. Anything else?
Well, I think we are right there at our end time, Matt. So I'll take it over if that's okay and kind of close out. One of the things I wanted to just let everybody know is that you'll get a quick survey from us after we conclude here today. We'd really love your feedback. So please take a moment and give that feedback to us. The presentation, as I mentioned earlier, is being recorded. It'll be available hopefully later today, maybe tomorrow at the latest. So if you want to revisit any part of it or hand it off to a colleague for review, please check it out on our website. Under Insights, you go to our events and it should be there for you to consume. And lastly, I got to do a plug. So I am in the marketing department, business development department here at Plunkett Cooney. So we have a really neat blog called Don't Bet the Business. Matt is also the editor of that blog and a contributor, as are a number of our other attorneys in the commercial litigation group. If you haven't checked it out, we encourage you to do so. You can leave your email address and get alerts every time content is updated. So Don't Bet the Business. Get the inside scoop with Matt and his group of writers on all kinds of different issues on risk management, business torts, things of that nature. Really, at the end of it all, we want to just thank you. Hopefully, you've gotten some good information, thought about some things maybe you hadn't thought about before. We're here for you. So if you have any questions, please let us know. All of our attorney contact information is on our website. We always love to hear from you. So with that, I will thank you for being here and wish you all a great rest of the day. Thanks for being here. Take care.